Hey everybody, before I get started with the meat and potatoes of this video, I want to make something very clear. The records you are about to see are public records. They are not leaks, they are not hacks, they are not private information. These documents, including Florida Commission on Ethics Form 1 and Form 6 filings, are publicly available records that are published on official government websites and other publicly accessible sources. Any member of the public can access these same records if they choose to do their own research. Almost all of the information you'll see in this video comes directly from government databases. Other information is compiled from publicly available websites that anyone can lawfully access. Nothing shown here was obtained unlawfully, and nothing shown here is protected or confidential information. I also want to be clear about something else. I am not telling anyone to go obtain these records. I am not instructing anyone on how to conduct their own research. I am simply showing how I access this information and demonstrating that it is publicly available to anyone who independently chooses to look it up for themselves. What members of the public decide to research, or whether they choose to research at all, is entirely up to them. There is no call to action here. There is no coordination. There is no encouragement to target or harass anyone. This is documentation and transparency, nothing more. I also want to point out important inconsistencies in the city's own disclosure practices. When private citizens appear before the Clearwater City Council to make public comment, the city requires them to publicly state their full names and, in many cases, their addresses, even though they are not public servants and are generally not legally obligated to disclose that information simply to exercise their right to speak. The city of Clearwater then records, publishes, and distributes that information itself. Those meetings are live streamed, they are archived on the city's website, and clips and meeting content are often shared across the city's official social media platforms. Yet when members of the public lawfully access and discuss public records about public officials, records the government itself choose to make public, that speech is suddenly treated as a problem. I also want to address something important before releasing these records. I'm going to put Florida Statute 112.23 on the screen so you can read it for yourself. This statute exists to protect the public's right to access and share lawful information, especially when that information involves public officials and public business. Under Florida law, it is unlawful for a government entity to attempt to use its authority, directly or indirectly, to suppress lawful speech or lawful content. That includes attempting to contact a social media platform to have a user, a post, or lawful content removed simply because the government entity or an official doesn't like that content or finds it inconvenient. The law also doesn't allow workarounds. A government entity or agent cannot do indirectly what it is prohibited from doing directly. That means it is unlawful for anyone acting on behalf of a government entity or a government official to attempt to pressure or influence or even contact a platform to remove lawful content, even if the agency or agents later claims it was unaware of the attempt. Retaliatory actions carried out by third parties, proxies, or so-called concerned citizens do not magically become lawful just because they weren't done with official letterhead. This video is about transparency, accountability, and public records. It is not harassment. It is not misinformation, and it is not unlawful. Everything you are about to see is protected speech, supported by public records and grounded in Florida law. I want to explain why this matters, and why I'm taking the time to say all this on the record. Recently, a man named Michael Taylor, also known online as the Armed Fisherman, was charged by the Clearwater Police Department for releasing information obtained from public records. Records very similar to the ones you are about to see in this video. In Michael Taylor's case, the police charged him under the Public Records Law, Chapter 119, that does not even apply to the private citizens. That statute applies to the government entities that hold and release records, not members of the public who lawfully obtained them. Once that reality came clear, that charge was quickly dropped. It's also worth noting that Michael Taylor partially redacted most of the information from the records he released. Despite that fact, under Florida law, he was not required to do so. He went out of his way to be cautious, and it still didn't stop the retaliation or the charges. Michael Taylor was investigating reports that the Clearwater city manager wasn't living in the city of Clearwater, which is a requirement in order to be city manager, and was allegedly claiming homestead exemptions on more than one property. Claiming multiple homestead exemptions is illegal under Florida law, and the issue he was raising involved the proper use of public benefits by a public official. Despite this being an investigation into public records and public conduct, Clearwater authorities have also claimed that Michael Taylor's actions constitute stalking. He is still actively fighting that charge. During this case, a judge, who's since been recused because she wouldn't allow his attorney to speak about this case that got dropped, warned Michael Taylor that he was not allowed to discuss anything related to the city manager and was not allowed to attend Clearwater City Council meetings. As a result, he has effectively been silenced by the city of Clearwater while his case continues. That's a big part of why he hasn't been releasing a lot of videos lately. I want to be clear about my role. I've been following this case closely, covering it, and attending many of the court hearings. Michael Taylor did not ask me to do any of this. During these proceedings, the alleged victim's attorney went so far as to claim to the judge that I record court hearings. That claim is false. I do not record court hearings. What I do is submit public records requests for the official audio recordings of court proceedings. Audio that the courts themselves record and provide to the public. This is a cost that I usually assume myself. It's about $25 per CD. Usually that's per hearing. I have obtained the official audio for all of Michael Taylor's hearings, and I plan to release that audio in the near future.
I apologize. I normally spend my time on the fourth floor, and I confused Hessinger and Register.
No problem.
I know my client is...
He's on Zoom.
Yeah. If you want to address that right
yes,
now?
please.
Okay,
Your Honor, if we may approach prior to addressing, do you want to?
Sure. Okay, come on up.
Your Honor, we're also on Zoom. We're also on Zoom.
Yeah.
Okay.
All right, what are we doing?
I didn't get a chance to address this prior, but this defendant is a YouTube. He's got hundreds of thousands of followers on YouTube.
Oh, okay.
One of his followers is in the room right now. They are known for recording court
Who
proceedings.
is this?
I'm sorry. I'm sorry.
Which
Michael.
one is the person?
Michael. David.
No.
Oh, with the sunglasses.
Okay.
So I just wanted to see the court's position on recordings in the courtroom.
No,
so if that could
it's
be
not.
addressed prior to
Yes.
calling the victim up to talk to the court.
Okay.
Okay.
Sir, you're not recording anything today, right?
No, ma'am.
Okay, just under...
I have my phone out. It's in my pocket. I also need to disclose something else. He's not the only one that they've silenced. The city of Clearwater already prosecuted me for protected speech, specifically for words I spoke during a recess of a city council meeting. That case is currently on appeal in the Florida 2nd District Court of Appeals. Despite the speech being protected, I was sentenced to 10 days in jail and 6 months of probation. That probation ended yesterday. While on probation, I was ordered that I could not attend any city council meetings anywhere. There are others who have been silenced also. Given what's already happened to Michael Taylor and me, it's reasonable to question whether further retaliation will occur after these records have been released, especially when the information being released is lawful, factual, and publicly available. There's one key difference between what Michael Taylor did when he released those records and what I'm doing here. I'm not redacting shit, not anything. I'm releasing these records exactly as they were published by the government entities themselves in their original form. This is the same information that the government chose to make public. So I know this video is already getting long, and I don't want to bore you much longer. But I do want to address this document you're about to see, because it has the word confidential written on it. Even though it's labeled that way, this document was obtained lawfully from a government source, and is still a public record under the Florida law. The fact that an agency marks something confidential, or fails to redact it properly, does not change the public record status of the document itself. I also want to be clear that nothing in this video is legal advice. Rather than turning this into a full legal breakdown in the middle of the video, I've put explanations, statutes, and case law in the description or in the comments depending on the platform that you're watching on. So anyone that wants to dig deeper can do so.
As well, Mr. DeLauder.
Good morning, Your Honor.
Good morning.
Got Michael David Taylor and the victim advocates waiting on your Zoom.
Yeah, I see that. Well, someone is Miss Clark's on Zoom there. Just put the volume on. Miss Clark, can you hear us?
I can, Your Honor. Good morning.
Good morning. Mr. Taylor, I don't think you were here for this, so please raise your right hand for me. Do you swear from everything about to say to be the truth, whole truth, nothing but the truth?
I swear.
Thank you. Put your hand down. You're here on a stalking charge. Looks like it was sent to us from Division R. And we're here to set it for trial or plea it out, I guess. So, candidly, I don't know much about this case. It's probably a good thing, right? Other than the fact that it's a stalking charge and it's getting to that point timing-wise in terms of that. So, let's take it from the top. Kind of state what is the offer that you're looking for?
Your Honor, our offer is adjudication of guilt, 210 PCJ, and I believe that's all.
And 875 court costs and fines, I'm guessing. The invest cost, if any?
It looks like $728.50 to Clearwater PD.
$728.50 to Clearwater, you said?
Yes.
Okay. So, all right. So I guess the big question is he going to plea, or are we setting him for trial?
Your Honor, we're going to set this case for trial.
Okay. Well, let's hear the factual basis, nothing else. I understand the defense may disagree with it, but at least the state's alleging.
Yes, Your Honor. This offense occurred on or between May 1st, 2021 to May 29th, 2025. The defendant is a YouTuber who goes by the name The Armed Fisherman, has made several videos airing his grievances against the victim, who is the city manager of Clearwater. Within these videos, the defendant has disclosed the victim's home address, her related addresses, phone numbers, photos of her home, her family members, and social media pages for family members. This has been going on for years. The defendant has also encouraged followers and or commenters to continue to harass the victim.
Okay. So obviously the defense's position is different, just to see at least kind of get a lay of the land here. Now, of course, I see Ms. Clark there. You'll have an opportunity to make a statement, if so, on behalf of the listed victim as the listed victim's attorney, per the Florida Constitution. But, in addition, let's pick a date. So, say, do you have a preference of, does that week work for you, the April 14th, 15th, 16th?
On our knowledge, yes, Your Honor, that should work.
Let me start with Ms. Clark, or move next to Ms. Clark. For your client, and I guess for your availability if you want to show up as well, does the 14th, 15th, or 16th work, or the 7th, 8th, or 9th? All of April we're talking about. I'm okay with going out that far, considering kind of that's a transfer case, and that's fine.
Your Honor, that week, I think it's the second week of the 13th, 14th, 15th would be wonderful if it could be that one.
Okay.
And Your Honor, just to add, there within the charge facts, there's also in-person acts.
Okay. Well, we'll find out. Again, that's for a jury to figure out more than anything else. But is there any statement from the listed victim that we should be buying through you, Ms. Clark, for today's purposes?
No, Your Honor, no statements from the victim at this time.
Okay, very well.